Vacancy Legal Recruitment, a refreshingly unique and personal talent agency developed specifically for legal. Dedicated to the sector and with extensive experience working across legal services and legal technology, we bridge the gap between your requirements and top-tier legal talent. Get in touch today and say hello at vacancy.co.uk.
You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Wills and Probate podcast. Today, I'm very excited to welcome Stephen Lawson and Elizabeth Gibbison to the podcast to talk about what might be on the agenda for the Law Commission's Wills Act report, which is to be published relatively imminently. We're recording this right at the end of March. Stephen is a partner at IDR Law and chair of the Wills and Equity Committee. Elizabeth is an associate at Irwin Mitchell and is chair of the Private Client Section Advisory Committee. Both of you have had some input or at the very least have got some understanding of what the Law Commission might have up their sleeve. And of course, we've got a couple of pointers in both the 2017 and 2020 reports that never quite made it as far as we've got so far this time. Thank you both so much for joining the podcast. In the first instance, Elizabeth, I wonder if you could give us a very short synopsis of who you are and what you do, please.
Certainly, and it's lovely to be here, David, and nice to meet you as well. So I am Elizabeth Gibbison, as you mentioned. I live here in the Northeast, and I'm very proud to be from here, though I do work with clients and peers nationally. I personally specialise in helping clients to preserve and protect their assets for those they love, including things like wills, trust, probate, all manner of tax and estate planning. And I work with clients generally to ensure that their wishes are respected and their estates are managed efficiently.
Thank you. And Stephen, if you could do the same, please.
Yeah, it's great to be here. We've definitely got a northern influence on this podcast today. I'm Stephen Lawson. I'm a partner at IDR Law. If people haven't heard of that, IDR stands for Inheritance Dispute Resolution. We are an unusual firm because there's about 25 of us lawyers, and all we do, the only work we do, is contentious probate. So you'll gather from that, I'm a pure contentious probate lawyer. That's it. That's what we do.
Fab, short and sweet. Well, it gives us plenty of time to get into the meat of today's discussion, which is the output of the Law Commission's Wills Act report. Not yet published, as I say, coming pretty soon. But we've been here before, haven't we? As I say, 2017, 2020. How have we got to this point, 2025, where we've finally managed to coalesce around the fact that legislation that was enacted 150 years ago needs to be updated? Stephen.
Oh gosh, the Law Commission, I'm a bit of a cynic when it comes to politicians, but the Law Commission was set up, in fact it's 60 years old as a body this year, and it was set up to reform, to improve, to simplify the law and to make sure that the law reflects social attitudes. And then in 2017, it did a consultation and produced a consultation on the law of wills, the whole of the law of wills. It looked at every conceivable aspect in relation to the law of wills. And my claim to fame is that I'm quoted in the footnotes of that consultation on about 5 occasions. I don't think anybody will have read that, so my claim to fame isn't actually that good. But they started by looking at, as I say, every aspect from how to create a will, whether you need witnesses to a will, what the test of testamentary capacity should be, every single aspect of the Wills Act of 1837, and they considered all of the common law issues arising as well. But then Parliament and the government, being what government is, said, well, we don't want you to look at this report anymore. We don't want you to look at wills. We want you to look at the law of marriage instead. So literally the law commissioners and the team there stopped all work that they'd started on the law of wills, and then moved on to the law of marriage, and then they finished that report, and then they did a supplementary report in 2023 which dealt with just two aspects, namely whether or not marriage should revoke a will and how we should deal with computer wills or electronic wills, if you like. And that timescale, although it was deeply, deeply frustrating, was probably to the advantage of everybody, because the story of Daphne Franks is probably well known, where her mother was in a marriage at a time when she had dementia, and so Daphne Franks became a strong influencer on that. And also in the intervening period, technology has moved along, so everybody's in a lot better position to talk about electronic wills. So they completed that consultation, the second consultation. They've gone away, they've squirreled themselves away in their headquarters in London. They will no doubt very soon produce a detailed technical report, and that report, if it follows all previous patterns, will then be supplemented by a draft wills bill 2025. Now, there's one very important aspect I need to mention, because we might touch on the issue of electronic wills. What the Law Commission does not do is draft statutory instruments. Now, that means that any of the technical stuff about electronic wills will be delegated to statutory instruments, and that means delegating it back to Parliament, and Parliament may or may not consult with relevant stakeholders, or the extent of that consultation is all up for grabs, let's put it that way. So it's all very exciting. There's loads and loads to look forward to. It will be a complete revision of every aspect of the 8 Wills Act of 1837. I can see legal textbooks authors getting very excited about the new books that they can write and the courses that can be produced if and when any Wills Act is implemented.
A hugely useful overview, but if we can drill into what we can take from some of those previous consultations, Elizabeth, what might we expect in terms of some of the detail of this report in the coming months?
I think what we can anticipate is sort of within the draft wills bill, potentially, it will cover electronic wills, as Stephen mentioned, and but however, it will defer the queries over how these are actually made in actuality and safeguarding provisions play out day to day. The bill will aim to, I think, enable the creation and recognition of electronic wills to reflect the increased use of digital documents and signatures, certainly as part of that. It will also look at things like marriage revocation. Stephen picked up on previous consultations looking at that, and the rule that a marriage or civil partnership revokes a will, which will be under review and remains under review, and addressing concerns about predatory marriages, as Stephen mentioned. Testamentary capacity as well will be looked into, so the test for that may shift to align more with modern understandings of conditions like dementia, and I think we'll also see some technicalities around formalities and validity around the formalities required to make a valid will, including the possibility of dispensing with certain formalities if the deceased's intentions are clear. What I don't think we'll see is anything to do with original will storage and what we do with these previous documents which have been made and remain valid. That remains a separate matter, as do some other things, such as whether or not there should be creation of a national register for wills, which currently is an opt-in system and it's not mandatory to do that. So I think there's quite a bit will be potentially covered in this bill, but there will be some gaps potentially as well there.
I want to drill into some of that detail in a little bit, but at a sort of high level, technology has got a massive role to play in 2025, when, of course, it probably wasn't really even thought about in 1837. How do we see that technology is going to play a part in the output of this report? You talked about electronic wills. I mean, there was obviously temporary reliefs or temporary enablement of virtual signing during the COVID pandemic. Do we see that that's going to come back? It throws up so many challenges, doesn't it? I mean, not least testamentary capacity and all that kind of business. I'm not sure what the question is in here, but perhaps there's a comment about what technology or what role technology has to play. Stephen first.
Oh, thanks very much, David. All of us could probably talk for 3 hours on this, so I mean, I will simplify it. Look, at its core, one of the concerns is protection, because we all know as practitioners that it tends to be older people who make wills rather than younger people. Now, the problem with that is that while some older people are very IT savvy and very astute, some people may not be. And there's a fine line between somebody's friend or neighbour, inverted commas, helping, close inverted commas, an elderly person to make a will, leading on to financial abuse, particularly if that will is made in the dark of somebody's home where there's nobody else around to see it, or whether you've got your next door neighbour and your next door neighbour's friend helping to make a will. So there are enormous concerns about potential abuse and the protections. However, I just want to reverse it a little bit and put this on the table, that at the moment everybody thinks that the system of having a will executed in the presence of two witnesses is pretty superb, and that can of course work particularly well, and that's the point of professional will preparers who are attuned to looking out for signs of abuse and who should, in situations of doubt, look at a capacity assessment and record that on a file. And all of that may be absent if there's an electronic will. However, on the other side of the coin, at the moment, all I need is to sign a will in the presence of two witnesses. I could take a will, a homemade will, into the local cafe, go into two strangers sitting there and say, "Excuse me, will you just witness me signing this will?" And then I create a paper will that on the face of it is perfectly valid because it complies with the statutory formalities. However, firstly, those two strangers, they don't even need to know as a matter of law that they're witnessing a will. So there's no attempt on that scenario to assess my capacity. And worse, there's no attempt to assess my identity. So I could be pretending to be you, David, and these strangers in the cafe wouldn't know whether I'm me or whether I'm you. The issue about protections can be reversed because with electronic biometric security procedures and client identification, there's an equally valid argument that a computerized will made in an appropriate form is something that will actually give a better protection than the outcome that I've just mentioned, particularly if the will making process is valid. And we've not even talked about artificial intelligence yet, but you can get artificial intelligence to back up and ask questions and save as part of a will preparation file of a person who is seeking to make a testator. So there's huge amounts of work to be done. There's huge scope to make an exciting opportunity. But that's why I mentioned earlier the fact about the concern that the Law Commission is likely, I would have thought, to leave that delegated part of a statutory instrument to Parliament. And that means the role of the Law Society and other stakeholders is absolutely crucial in the future going forward.
So I agree with Stephen. I think it's a really exciting time and this is an opportunity, but clearly there are some issues that also need to be ironed out with things being much more modernised when it comes to making wills. And I think, you know, the aim will be to create a balanced approach that leverages the benefits of digital tools by, you know, while at the same time maintaining the integrity and security of the process of making wills. And I almost think that modern day living is forcing the law to keep up, really. I mean, you know, around the world, in some states in the US, they've enacted laws recognizing electronic wills, allowing them to be created, signed and stored digitally. And, you know, other places have also sort of introduced these measures, such as Canada, Australia, New Zealand, and others. So I think, you know, we do need to keep up. And while the use of technology in such a sensitive area understandably raises those concerns that Stephen mentioned earlier, it's important to also consider the potential benefits and challenges to allow the law to keep pace with modern technology.
It's important that people listening to this understand what we're talking about when we're talking about electronic wills, because
Yeah.
there is potentially a little bit of uncertainty, right? I could pick up my mobile phone
Yep.
and say to my mobile phone and record it, or my laptop, this is my last will and testament. I want to appoint my wife as my executrix and I leave everything to her, okay? That might be regarded as an electronic will, but that is not what is being considered by the Law Commission as an electronic will. Their scheme will require a statutory approved process to make a will, all right? So it would have to be in some sort of formality that complies with regulations set out by the Secretary of State. However, one of the things that the Law Commission also did in the 2017 report is that they recommended that there should be what's called a dispensing power. In other words, a power by a judge to dispense with the formalities that apply to the law. So, for example, we all know at the moment if a will is only witnessed by one witness rather than two, then it's invalid, no matter how much the testator wanted that will to be valid. Now, there was a lot of support for the provision of a dispensing power, and I didn't see any opposition to it. So, in other words, in future, the Law Commission might come along and say the court has the power to dispense with formalities and recognise as valid a will that would otherwise be invalid. Now, the reason I've mentioned that is to avoid any confusion about this, because what the dispensing power could do, if somebody discovered on my mobile phone or my computer laptop a document that doesn't comply with the statutory formalities, but which a court accepts is intended to be my last will and testament, the court might have power to recognise that. So forgive me, David, for mentioning that, but there are two separate issues, right? There's a lot of confusion when I talk to people about what they mean by an electronic will. An electronic will, I stress, is not just saying it onto my mobile phone. It would require compliance with a statutory process, whatever that process might be, and it would involve identity, proof of identity of the person making the will. But a mobile phone will might be recognised as valid under a dispensing power if the Law Commission recommends that change to the law. So sorry to butt in with that, but I just wanted to clarify that aspect.
I mean, that's a very relevant point in the context of probate as well, isn't it? Because there are very few checks and balances when it comes to, for example, going to the bank when you've got your grant of probate or you've got your death certificate, and withdrawing sizable amounts of money on behalf of people who have died. So yeah, I get that completely. I want really to finish on this tech point because we could spend, as you say, most of the day talking about this, and there are other things we want to cover. But do we see, Elizabeth, that technology is going to make the ability to make a will, and bear in mind that that's a real core focus or should be a core focus here, do we think that it will make the ability to make a will more accessible?
I think that modern technology will make the ability to make a will more accessible for some of the population. Stephen did touch upon earlier the fact that there are people who aren't technologically savvy, where there may be sort of cause for concern around how they get to the point where they make a valid electronic will if they're being assisted by others. And I'm sure it'll only keep contentious lawyers ever busier in this area around issues with potential undue influence, etc. So I think, yes, accessibility may be increased by way of the measures to introduce electronic wills that will potentially allow more of the population to create and update their wills. It might also increase things like efficiency around, the process at the moment of drafting, storing and retrieving wills it can be quite cumbersome. So that might also be addressed with the use of technology. And with the measures Stephen mentioned earlier around ID being required to make wills, which accord with legislation, this could also increase security as well if properly implemented. So I think ultimately people will benefit from this, but by the same token, the individuals who aren't technologically savvy will be adversely impacted by these changes if they are imposed and overtake previous legislation around will making.
Other elements of the Law Commission's report, we think, is going to focus on that test of capacity. Capacity is a hugely difficult issue, as you say, Elizabeth, will no doubt keep people like Stephen busy for many, many years to come. We're still working with a precedent that is donkey's years old. We've got legislation that followed it in the Mental Capacity Act that it still isn't sort of enshrined as the de facto view of what capacity should be. This is very muddled. Where do we go from here, Stephen?
Right, well, you probably don't know this, but I wrote a book in 2014 with a psychiatrist and an academic called Testamentary Capacity, and we put the will of John Banks from the Test of Banks and Goodfellow on the front cover. I am an absolute passionate advocate for what is known as the Banks and Goodfellow test, because no matter how old it is easily understood. People need to know what a will is, that they're making a will. People need to have the ability or the capacity to understand what their assets are, and they need to have the capacity to be able to understand who might expect to benefit from their estate, and that no disorder of the mind, etc., shall poison their affections. Now, I find that, and practitioners find that, and members of the public find that a relatively easy test to comprehend. Now, if the Law Society, because there's a huge, I've been lecturing on this subject for many years, which is why I can keep going on about it, but there's been this huge row going on, and indeed Irwin Mitchell led the charge for suggesting that the test of testamentary capacity should be the Mental Capacity Act rather than Banks and Goodfellow. And that was in a case called Clitheroe and Bond, which had numerous hearings at numerous levels of the judiciary. But there have been other attacks on it. So how the Law Commission will reconcile the well-established Banks and Goodfellow test with the Mental Capacity Act test remains to be seen. Now, I am troubled, although I am fully supportive of what the Law Commission has done and the way they've consulted. Well, firstly, they said in the 2017 report that the Banks and Goodfellow test worked well and was understood by the public and the profession alike. So I would be holding their feet to the fire on that. But they also said that if they were to change it to the Mental Capacity Act, it might be supported by a practice direction of some sort and amending the Mental Capacity Act Code of Practice. But I've already said twice now that the Law Commission don't do the statutory instruments, so they will be walking away from a job, as far as I am concerned, half done, should they shift from Banks and Goodfellow to the Mental Capacity Act test, because it may be seen as difficult to reconcile the two tests, although some people have tried to reconcile them and say that they're the same. But there we are. It's a battle yet to be resolved.
I mean, I'm of the view that the legislation around this actually can support the Banks and Goodfellow test. I agree with Stephen. I think that test itself is very self-explanatory and it does what it says on the tin and it works very well. But personally, if I'm asking for a full assessment of testamentary capacity to be carried out by an external professional, or if I'm doing that myself, I will look at the main provisions of the Mental Capacity Act, go through the Banks and Goodfellow test, and ensure that I'm happy that the main provisions are met in that act, such as the presumption of capacity is decision specific, looking at things like how people are weighing, retaining and communicating information and all that other stuff that comes under the ambit of the Mental Capacity Act, which sadly I studied for 2 years alone and produced a thesis on the Act, so I have a bit of an affinity with it. So therefore I think I agree, but I do think there is a middle ground to be sought, and I think the two can complement one another.
There are a lot of moving parts in this whole debate. I mean, we've not really even talked about the age at which people can make a will. We should probably touch on undue influence, simply because that is an increasingly important area of law. You're seeing that in the family community. Listeners to the podcast will be aware that we've got today's Family Lawyer podcast and publication, and domestic abuse and coercive control in that area of the law is massive. And so here's an opportunity for people in those sorts of controlling relationships to take control of something that's very, very important to an individual. And at the moment, there are checks and balances, as you say, Stephen, from the point of view of having to physically have two people in front of you to sign something. But if we move towards a more electronic process, is there a risk that we're not going to protect those most vulnerable in society from undue influence?
Right, well, you raised two issues there. You raised the issue about the age at which you can make a will. Age is something that fascinates me because that was a matter as well that the Law Commission consulted on, and they wondered about reducing it. Now, most of your listeners have probably heard of Luke Littler, the superb world darts champion, and the amount of money that he's won. Although he's won all this money, he can't make a will to decide what to do with it because he's under the age of 18. However, it also seems to me that the law is in a bit of a mess because even if they reduce the age at which he can make a will to 16, he still can't buy his own darts because you've got to be 18 to buy a sharp implement like that. He can't make a lasting power of attorney because you've got to be able to at 18 to do that. He couldn't get married because you've got to be 18 to get that. You can't vote because you've got to be 18 to do that. So we are at a little bit of a risk of having ages all over the place about what you can and can't do at different ages. Now, I don't even want to get into that because it's a completely different debate whether you harmonise the age at which you can do various things. But you are absolutely right. That is on the Law Commission radar to be able to reduce the age. The bit about undue influence, as a litigator, one of the most common things that we get, members of the public ring up and go, I want to challenge this will on the grounds of undue influence. It must be undue influence because why else would my auntie have done what she's done, right? They have absolutely no evidence. And undue influence is one of the easiest allegations to raise, but one of the most difficult to prove. The Law Commission recognised that. And I remember going to a meeting in London after the 2017 consultation. They gathered together a group of stakeholders, including psychiatrists, leading barristers. I think there was a judge there, a chancery judge, and practitioners. And they well reflected the concern about the difficulties of being able to prove undue influence. Following that meeting, they took all that on board. And I know that the Law Commission is likely to look again at the law relating to undue influence, and that will be undoubtedly one of the matters that they will refer to in their final report. So I could well see changes about that when the report comes out.
The challenge here is doing justice to changes that are going to make a massive, massive impact on this sector in such a short space of time that we've got on the podcast. I mentioned that we're recording this at the end of March. It's actually the spring statement today. We haven't yet got what the output of that is. But generally speaking, this is a huge year for private client, isn't it, Elizabeth?
It really is. I agree, David. I mean, this year, the landscape of private client law is undergoing significant changes driven by potential new legislation and policy shifts. I mean, as an overview, here are the key areas really to watch and the things to have on the radar this year. We've got, as we've talked about extensively today, a review of the law around making wills. We've got changes to inheritance tax, which were introduced via Chancellor Rachel Reeves in the Autumn Budget 2024, and two other taxes which will impact how we deal with estate planning for clients and how we deal with that effectively. There's the non-dom regime changes, the terminally ill adults end of life or otherwise known as the Assisted Dying Bill, which is also on the radar with its second reading taking place at the end of last year. So there's that. There's also the general digitisation of legal processes, including the way in which HMCTS and the Probate Registry process applications for grants, the way that the OPG are dealing with, LPAs, and that's another exciting development with shifts in the way that these documents are processed and made, aiming to streamline everything really and make things easier, reduce paperwork and improve accessibility generally. We've also got the Great Wealth Transfer, which rumbles on, and with the imminent transfer of that wealth from baby boomers, there is the pressing need to continue to modernise estate planning and tax and succession planning, and just the general landscape of private client law this year. It is marked by significant potential legislative reforms, as mentioned, and those technological advancements that Stephen and I have touched on as well today. So, it's ever more important that private client lawyers are in the know, and it's a super interesting time for practitioners and clients alike.
I've got two more to add to that. It just shows what a big year it is. In 2009, the judiciary started a process to revise the non-contentious probate rules 1987. They produced draft rules in 2013 and then left them on the shelf. They never implemented them, although they had produced them. They're going to look again now at updating of the non-contentious probate rules, so that is going to happen. And we've also, one of the first things that a law student learns is there's no such thing as a common law spouse. Well, in 2014, the Law Commission recommended that to keep up with social attitudes, cohabitees in a long-term relationship, and that was over 5 years, should have the same rights on intestacy as a spouse. And that period should be reduced to 2 years if they had a child together. The Labour Party has brought that provision back because it was never implemented by the last government. The Labour Party is consulting on that and has consulted with the Law Society about those changes. So it is likely that legislation will be brought forward before too long to give unmarried couples in that situation the same rights as married couples. I'm a little bit of a cynic because although the government portray it as same rights, I understand they're not proposing to change the law in relation to inheritance tax because, of course, at the moment, if a spouse receives their other partner's legacy, there's no inheritance tax between spouses, but the government is not proposing to change the law in relation to inheritance tax for cohabitees. So take with a pinch of salt when the politicians say it's going to be the same. It ain't, but it is going. If that is implemented, that will be a vast change to practice across the board.
My favourite common law spouse story is the fact that if you go and renew your car insurance at the moment, and you go on Go Compare or Compare the Markets, under marital status, in that drop-down menu, it actually says common law spouse, doesn't it? And of course, we all know it doesn't exist, but while we perpetuate that myth, it's no surprise that people continue to believe it. I want to ask you both your opinion on the timing of the changes that we are hopefully going to see about wills, and we're also going to discuss where we can go over the course of the next 12 months to find out more, including the Law Society's private client conference, which is coming up very soon. But I want your thoughts on whether now, given everything that you've said about the changes that are going to happen over the course of the next 12, 18, 24 months, the great wealth transfer, which of course we can't go anywhere without talking about at the moment, how realistic it is to introduce seismic changes to legislation at a point in time when so much is going to happen, and we almost need that comfort blanket of precedent rather than creating a whole new potential precedent?
That's a really good question. I think, yes, it is crucial that with the imminent great wealth transfer, we do modernise our processes to ensure that they are efficient and secure. It would be great if there was a case that came to court in the interim where we would have some further precedent in that sense, where there is consideration based on the now rather than us waiting for legislation to be passed, which would then be padded out by statutory instruments and all that sort of stuff. So I think, yes, hopefully this will happen fairly soon. If it doesn't, I think we'll be forced to consider the issue more. There was recently I think it was a High Court judgment actually, on whether or not there was a deathbed gift made via somebody sending, I think it was a text message or something along those lines. So I think these cases are becoming more and more prevalent, and where, that there has to be consideration of how technology is used in this sphere, even ahead of legislation being passed fully.
There are huge changes. I always used to joke that, private client practitioners didn't need to update their textbooks because the law always stayed the same. Well, the pace of change has never been so great. One of the problems is that Parliament has a bit of a habit of ignoring Law Commission reports or putting them on the shelf themselves. And so Parliament recognised that actually, and it's now that every year the Lord Chancellor has to give a report to Parliament saying these are the Law Commission recommendations that we've implemented and these are the recommendations that we've not implemented, and that report is just publicly available. And as I've already said, the 2014 Law Commission report on cohabitees has been ignored since that time. So there is a prospect that Parliament might find that there are what other things that they consider to be most important. I consider that, this to be most important to the day-to-day life of every citizen in this country. The right to make a will is fundamental and how you go about that. But there is a possibility, and I put it no higher than that Parliament might choose to ignore it or not find time to deal with it. But I think as Elizabeth has said, it is likely that time will be found somewhere and that these changes will be implemented. That would be my guess. How they implement the electronic wills process, I suspect might take longer, but they can introduce it. The whole bill doesn't need to be effected all at once. They can implement it in different stages. So we might find all of the wills bills is implemented, but apart from, say, electronic bills, if they think they need more time to work on the procedures to be adopted. So exciting times.
Elizabeth, you said that it's never been more important for practitioners to keep up to date with what's happening. Clearly, podcasts like this are one route to do so. There are a number of events over the course of the next year as well. And of course, one of the key events of the year is the Law Society's Private Client Conference, at which I expect you both to be there, given your roles. What is the agenda for the day? What do we expect to be covered during the course of the conference?
The Law Society's Private Client Conference on the 20th of May this year is a must-attend event for all private client practitioners. Listeners can expect a comprehensive overview of the latest developments in private client law, including discussions on the budget and spring statement happening today, navigating complex estate admin, the Wills Bill 2025, advising modern families, farming families. There'll be discussion on statutory wills and court of protection applications, further discussion around digital change and AI affecting private client work, and more. The conference will feature a variety of expert speakers, interactive sessions, and valuable networking opportunities. It allows private client lawyers to be in the know and add to their technical armoury.
A not to be missed event, and one definitely for the calendar every year, actually, because it's an important event in the private client calendar. That's as much as we've got time for today. It's a bit of a whistle-stop tour through what we might see in the Wills Act and sort of more generally what's happening in and around the private client sector over the next 12 to 18 months. Thank you to Elizabeth and to Stephen for your input and insight. Thank you both.
Thank you so much, David and Stephen. It's been a pleasure speaking about all of these topics today.
Likewise, there's much to talk about.
Today's Wills and Probate podcast is available on your preferred podcast provider. It's also available on todayswillsandprobate.co.uk. My thanks to Elizabeth and to Stephen. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.